Under Section 9 of the Foreigners Act, the burden of proving that one is a citizen of India and not a foreigner falls upon the litigant. Hence, it is a reverse burden of proof. So, a person appearing before the Foreigners Tribunal has to prove their case that they are not a foreigner and that they are an Indian, as opposed to the central government proving that they are a foreigner. However, the promulgation of the 1983 Illegal Migration Determination by Tribunal Act, the IMDT Act, reversed this position. Under the IMDT Act, the burden of proving that a person was a citizen of, that the person was a foreigner fell upon the central government, unlike the provisions under the Foreigners Act. Further, the IMDT conferred exclusive jurisdiction upon courts to determine a question on these tribunals, to determine the question as to whether someone was a foreigner or not, which meant that persons were barred from approaching the civil jurisdiction to determine this question. However, in 2005, the Supreme Court of India in Sarbananda Sonowal 1 struck down the Illegal Migration by Determination by Tribunals Act and conferred exclusive jurisdiction of citizenship determination questions to the Foreigners Tribunal system. Hence, from 2005, the Foreigners Tribunals continue to solely hear questions relating to citizenship determination, as and when referred to it by the Assam Border Police Organization. The Foreigners Tribunal's order of 1964, while there have been certain amendments made to it over the years, it still does not have a legislative form, which continues to show that it operates in the way the executive order was promulgated in 1934 and does not take the form of a legislation, which further bolsters the point that the IMDTs, while they served a judicial function, the Foreigners Tribunals were initiated to serve an executive function. However, without any changes to the structure of the Foreigners Tribunals order, post 2005, the Foreigners Tribunals continue to hold a judicial function which they were not intended to on the initiation of the Foreigners Tribunals order of 1964. As mentioned, the Foreigners Tribunal's order also reverses the burden of proof upon the litigant, which makes the process of proving someone's citizenship extremely onerous in these courts. And since members who are judges of these tribunals are allowed to regulate their own procedure, the process in each tribunal of the 100 tribunals that exist in Assam today differs over certain time and periods and in the way they apply the law, which makes proving one's case further more difficult. While the tribunals have assistant government pleaders or AGPs who appear before these tribunals to prove the case of the government, in many cases it has been observed that the AGPs continue to remain absent in the tribunals, which means it is solely the litigant who is appearing before the tribunal, along with the member who acts as an assistant government pleader as well as a judge, meaning the member in multiple cases plays multiple roles, which the state or the central government should ideally have taken up. All of these conditions, as well as the extremely onerous documentary burdens on a litigant in the Foreigners Tribunals, as well as multiple documented instances where oral evidence continues to be disregarded by these tribunals, makes it an extremely onerous process for litigants to prove their case before these tribunals. Another issue that pervades the Foreigners Tribunal system as a challenge for the litigants is the lack of available legal aid through state mechanisms in Assam. There are over 1 lakh cases pending before tribunals in Assam, and there are about 100 tribunals. If we account even for an equal division, there are about 1,000 cases pending before each tribunal, and each tribunal only has 1 member or judge who officiates cases. Along with this, there are fresh references being issued daily as well, which means that for the large number of cases pending in the system, there are not enough lawyers who are able to represent people who appear before these tribunals. Considering the persons who appear before these tribunals are also extremely marginalized, a lot of the times they cannot pay lawyers sufficiently to ensure there is effective representation before these tribunals, which also has dire consequences. The consequence of declaration by a tribunal is immense in the sense that a person is declared a foreigner by the opinion of the tribunal, and hence effective legal representation is an important way through which this issue can be addressed. Since the financial and monetary burdens of this upon the person are too high, and a lot of them cannot afford to engage lawyers who are well versed with the facts of citizenship law and well versed with Foreigners Tribunal jurisprudence, invariably leading to a system where multiple people are not aware of the status of their case, are not aware when the next date is, are not aware of how the legal process goes on, and hence it affects their determination as citizens and invariably gets them declared as foreigners.